Law in practice. The jurists of all countries admit that it is necessary to differentiate between international law and national law. The latter is also called domestic law or municipal law. Domestic law is the law which is applicable within the boundaries of one state. International law is the body of legal rules that regulate relations between sovereign states. It is a special system which is not a part of the national law of a state. There are some important differences between international law and domestic law. Domestic laws are passed by legislative bodies, most of which have popular political support. International laws, on the other hand, are created by agreements between governments of different states. As a result, they don't have a support from individual citizens. Enforcement of international laws is also different. Many international agreements or treaties are not binding. Even when nations agree to be bound, it is unclear how obligations are to be enforced. Sometimes, especially at the time of conflicts, the enforcement is provided by great powers. Countries differ greatly with regard to the importance attached to international obligations. Some states consider international obligation superior to their domestic laws, but in most cases international obligations are considered as a part of national law. The Russian Federation has admitted the priority of international law over national law, especially when it comes to human rights and individual freedoms. The 1993 Constitution has confirmed the trend in Russia's practice of giving a prominent place to international legal standards in the domestic legal setting. One of the principal aims of the Constitution is to clarify the status of international law in the Russian domestic system of law. The Constitution contains a special clause on the relationship between international law and the Russian domestic law. Article 15 provides that the generally recognized principles and norms of international law and the international treaties of the Russian Federation shall constitute an integral part of its system of law. It also states that if an international treaty of the Russian Federation established other rules than those stipulated by the law, the rules of the international treaty shall be applied. Two principal features of this article must be pointed out. Firstly, it states that international law is part of the Russian domestic system of law. Secondly, it established a higher normative status for treaties than the domestic laws. Consequently, legal regulations within Russia don't apply if their application is incompatible with treaty provisions. The Constitution also includes Article 17, which provides that human rights in Russia are recognized and ensured according to the generally recognized principles and norms of international law. Thus, every citizen of Russian Federation, in case of violation of their basic rights and freedoms, has the right to apply to one of the international organizations, for example, to European Court of Human Rights.